Hi, I'm Allie, Jett.
And I'm Brad Hutchins, and together we lead the property tax law section here at Weissman. We've done some videos in the past for you guys to give you some updates on a decision that came out from the Court of Appeals in November of 2015 regarding superliens, the creation of the superliens, and who's entitled to excess funds resulting from the superliens. Since November 2015, we've all been waiting with bated breath to find out what the Supreme Court was finally going to say about the Court of Appeals decision from November 2015. Well, last week, we finally got a decision from the Georgia Supreme Court, and now we understand superliens and excess funds.
To give you a little bit of history and reminder, the November 2015 decision from the Court of Appeals had changed the long-standing rule that a redeeming creditor who redeemed a tax deed could get a superlien, and that as part of that they could both foreclose on the property and claim the surplus funds that had been generated by the tax sale. The Court of Appeals did away with that long-standing rule and said that a superlien holder could only go after the property, that surplus funds could only be distributed to parties who had an interest in the property at the time of the tax sale. A superlien, as we all know, necessarily arises after a tax sale through the redemption of the tax deed, and so therefore, under that Court of Appeals rationale, would not be entitled to take down those surplus funds.
Now, the Georgia Supreme Court last week came out with the same ruling as the Court of Appeals, i.e. that a superlien holder is not entitled to the excess funds resulting from a tax sale, although they can go foreclose on the property in order to satisfy their superlien, but they used a different rationale. What the Georgia Supreme Court case said is it's not the fact that the superlien doesn't exist at the time of the tax sale that matters. It's the fact that a superlien attaches to real property, and the excess proceeds resulting from the tax sale, the money, is personal property. So since the superlien only attaches to real property, the superlien holder cannot get to the personal property, the excess proceeds. The interesting thing about the Georgia Supreme Court decision and looking back at the Court of Appeals decision is with the Court of Appeals decision, we finally had a clear ruling that you had to look at the liens that existed at the time of the tax sale in order to know who got excess proceeds. While the Georgia Supreme Court said the excess proceeds were personal property and a superlien holder could not get them, they did not speak as to the timing of the lien and the distribution of the excess funds. So now we're left open with the question: does the lien have to exist at the time of the tax sale in order to be entitled to excess proceeds, or can the lien come after the tax sale and still be entitled to excess proceeds? And I'm speaking of liens other than superliens. This is a question now that's open. We think the best practice is to make sure your lien attaches to the property at the time of the tax sale if you're going to get the excess proceeds. But again, this has left a little gray area in the law resulting from the Georgia Supreme Court decision.
Brad and I have also created the Georgia Property Tax Law blog. We routinely update that blog with any real estate property tax or personal property tax cases that come out that might be of interest to our audience. We don't necessarily do these videos on every case that comes out. We did want to do this one since we had promised an update from some of our earlier videos. So if you would like to check out that blog and subscribe to it to obtain regular updates on all manner of property tax matters, please feel free to do so. There will be a link in the description following this video that you can click on that will send you to subscribe to that blog. Thank you.
Thank you.